Thank you, Mr. Speaker. May I congratulate you on your appointment? Mr. Speaker, this bill introduces fairly substantial amendments. While I do agree with most of the amendments here, I have some concerns and require some clarification regarding this bill. I first talk about the suspension of Management Council and appointment of official management. Clause 53 of the bill introduces new sections 126A and 126B, which confers on the Commissioner new powers to suspend the Management Council of the Management Corporation if it is satisfied that the MC is unable or refuses to carry out a duty under the Act that must be urgently carried out to remove any danger to the health or safety of the owners or occupants of the units, and for such MCSD to be placed under so-called official management. These are very stern, if not drastic measures, potentially threatening the status quo of the management of MCSD. I'd like to ask the Minister what will be the circumstances that the Commissioner will be considering when making a decision to suspend the MC or to appoint an official manager. Will this recourse be abused by minority owners in the MCSD who may, for reasons unrelated to the conditions in Section 126A and B, be disagreeable with the current management of an estate? For example, rival owners who may have lost out in MC election or are disagreeable with the current management's plans or management priorities. I'm concerned that the conditions stated in Clause 126B1B is too general and may be open to unintended abuses. Perhaps the requirements should have been spelled out in greater details in this bill or even in the subsidiary legislation behind the Act, for greater certainty and to prevent abuse. I next go on to the expansion in the definition of common property. There is an expanded definition of common property under the interpretation section in the new Section 2C with 4 areas, namely 1, pipes, wires, cables, or ducts used or capable of being used by 2 or more occupiers. 2, the cubic space enclosed by a structure enclosing pipes, wires, cables, or ducts. 3, any structural element of the building. And 4, the waterproof membrane attached to an external wall or roof. The amendment also provided 5 examples. While the inclusion of the above areas may provide helpful access and management by the MCSD and the MA, I'm concerned whether it will also provide more grounds for misunderstanding or disputes between owners and the MCSD or MA. There are likely to be cases that may be different from the 5 examples given and may not fit in clearly to the straitjacket of the 4 areas in Section 2C. On the other hand, the new 4 areas in Section 2C may create new scenarios where disagreement or dispute may result. Let's take example D in the new section. It appears that a fire sprinkler protection system is now part of common property. Owners of an office strata unit may now need MCSD's consent to make changes to the fire sprinkler system within their strata unit. And if so, what if MA unreasonably or MCSD unreasonably withhold consent to the work intended or require something to be done to the disagreement of the owners for reasons of cost, design, or otherwise? Would a renovation not be held up? What are the options open to owners in such a situation if they do not agree with the MA or MCSD? Finally, with the new areas in Section 2C, I'm concerned whether or not this may become a double-edged sword for the MCSD or MA, or even owners, as parties learn who will be responsible for what. Some owners may take the opportunity to push the boundary and push certain responsibility to the MCSD. I next touch on the area of imposing budget. The new Section 38(3)A imposed upon the MC the need to have the budget for 1, the organizing of any social, cultural, educational, or sports activities that is for the benefit of all subsidiary proprietors and occupiers, as well as 2, engagement of legal services for the Management Corporation to be placed for approval as part of an annual budget at the AGM. The above 2 items of expenses are new additions under this bill and inserted in Sections 38(3)D and E. Organizing of social, cultural, educational, or sports activities are arguably not new to condos or private estates as such. Neither is the need for MC to use legal services. However, what is new is the budgetary requirement in Section 38(3)A, that is to say, the need to have the budget be approved for these items at an AGM. In Section 38(3)B, a further new amendment proposes that the MC may convene an EOGM for approval of budget for unforeseen or urgent expenditure for the same 2 items. I find this slightly troubling. First, the need to go to EOGM for these two items of expenditure may be cumbersome for not just the MC, but the residents as well. The attendance of residents in most MCSD AGM is hardly ever glowing. If the MC wants to hold a simple event for the residents, which was never budgeted previously, it will be put off by the trouble to try to hold the EOGM, not to mention the likely difficulty of getting a quorum. Residents may feel it may not justify their time. The new measure requiring the budget to be approved beforehand at the previous AGM may also mean that MCs may resort to the practice of setting aside a kiasu budget, which is needlessly larger than necessary, and may not encourage prudence. It may stifle attempts by active MCs to constantly come up with new activities to encourage residents to fraternize and also building up of the community relations within the estate. Would this lead to external organizations, whether commercial or statutory, coming up with sponsorships of events for their own agenda, particularly given that budget is always an issue which affects MCSDs? Would it not be better to have a more general regulation, leaving it to owners in each MCSD to decide what kind of budgetary constraints or authorization they wish to impose on the MC? This can be done at AGMs, or even through individual bylaws of each MCSD. Does the law need to interfere now with this new budgetary requirement? Next, I'll touch on the area of improvements, which increase the floor area. May I clarify with the Minister for the proposed amendments to Section 37, specifically the new subsection in Section 37(4)(a), where the MC will have power to require any owners to carry out rectification works in the case of any breach of Sections 37(1) and 3, will the MC be able to take action against the current owners if the work was carried out by a previous owner? If the answer to my question is yes, would the owner be able to seek recourse against the previous owners? And if the position on this is unclear, would the Minister consider amending the legislation to allow the right of recourse, at least in certain prescribed situations? Separately, if an action is being taken by MC under Section 37(4)(a) against an existing owner, and such action has not come to an end, will the MC be entitled to file a caveat against the property in case the property is being put on the market? This may serve to protect innocent buyers who may not be informed of the alleged breach or any related action the MC may be taking against the existing owner. Finally, I touch on the ban on double appointment holders in MC. The new Section 53(9)(a) prohibits a person from holding more than one appointment in the MC for the following appointments: Chairman, Treasurer, and Secretary. While I can understand and support the rationale for this new rule, I'd like to ask the Minister, would the proposed exception that the Minister have just mentioned in your speech be applied in the case of MCSD that's owned by a few owners, for example, just 2 or 3 owners? Thank you, sir.